Welcome to Conveyancing Matters with Lorraine and Stu. Join us for a chat about all things property. So, hello, Stu. A little bit of time off YouTube over the summer. How are you?
I'm very good, Lorraine. How are you?
Yeah, I'm all right, thank you.
Good stuff.
So, Stu, back in June, we talked about the ongoing saga, really, of the
Yep.
Property Information Form 5th edition. And frankly, in my opinion, the mess that the Law Society
Yeah,
made in relation to the rollout of it. We've now had the special general meeting that the Law Society had to convene because some of its members insisted on it. So I thought we'd perhaps just sort of talk around sort of where we might be at now with the Property Information Form 5th edition. That makes sense?
absolutely. Yeah, of course.
Good. Well, if any conveyancers are watching this and they have been in a cave for the last 6 months, I mean, a very brief, just to bring people briefly up to date, last November 2023, Trading Standards introduced material information requirements, which supposedly, are new in the sense that they just expand and amplify what the consumer protection regs right back from 2008 have required sellers and agents to be dealing with when a property is marketed. And what Trading Standards did was sort of add lots of additional information which they considered in their guidance to be material to a buyer's decision as to whether or not to purchase a property. The snag is that, as we discussed in our June 2024 chat, if anybody wants to go back and have a look at that, Stu, that material information, Part C in particular, it really drives its tanks onto the conveyancer's lawn,
Yeah,
doesn't it? It talks about building safety, construction materials, is the property in a flood risk area? Is the property in a mining area? And Stu, whatever those issues are, they're very firmly issues in the buyer's remit, aren't they?
yeah, absolutely.
What you would expecting to be found out
Yeah,
when acting on a purchase.
yeah, during the conveyancing.
Um, I think it's fair to say that some people have accused perhaps the likes of me for trying to point out some of the issues with this as being a bit negative. And it's not intended to be negative, it's just intended to be practical, because what the Law Society have done, as most people know, is back in March they produced the 5th edition of the Property Information Form, which effectively just adopted Trading Standards Material Information
Yeah,
Guidance, lock, stock and barrel, pretty much. And they produced a pretty appalling version of the Property Information Form, which the Law Soc originally said conveyancing quality scheme firms had to use from June the 25th. And there was, to be fair to property lawyers, a bit of an outcry. Lack of consultation, lack of transparency, and actually seemingly a very significant increase in potential liability on both conveyancing solicitors and their seller clients as a result of using the new form. So a special general meeting was convened, Stu. Enough people made a fuss, which happened on July the 23rd. And what the Law Society have done is sort of push back the compulsory rollout for CQS firms of the PIF until next January 2025. But we are left in this sort of strange limbo position now where the Law
yeah,
Society have said, well, we're having a consultation.
yeah,
But what bothers me, Stu, is that given that the PIF in its current format, which I'm hoping the Law Society, has the humility to accept is a mess and is prepared to amend, we do have this really strange sort of hybrid situation now where some firms are using the 5th edition, some firms are using the earlier 4th edition. There seems to be a lack of clarity in the market. And the Law Society have really handled this rollout quite badly, haven't they?
absolutely. Yeah, you can't argue that one.
So the special general meeting, Stu, I did attend it as a solicitor with a current practicing certificate, and I did actually make a small 3-minute contribution, just trying to pick on some of the points that were made. The motion was basically a motion of no confidence in the Law Society, and I actually spoke for the motion because I feel that the Law Society did handle the rollout of the new PIF very badly indeed, which I think has rightly shaken the confidence of practitioners. The motion wasn't carried, so the Law Society were successful in defeating the motion. And it's fair to say, Stu, that it was called a debate. It wasn't a debate. It was people just putting their side of the argument for 3 minutes. There was no
Yeah.
interaction between the speakers. But it was well chaired, and it was civilized, and you know, and practical, and there were no sort of teddies out the prams. I have to say, I feel that some of the speakers didn't take the opportunity to really hammer home the points about the problems with the PIF as effectively as they could have done, if I'm really honest, and I could perhaps include myself in that. I think what bothered me a bit, actually, it's such a dull point, Stu, but we were given 3 minutes to talk,
Yeah.
and
Yeah,
we
it's
were
not
told
long. Not long,
but
is
we
it?
were told the 3, and which is fair enough to give lots of people the chance to contribute within a 2-hour period, so that's fine. It's a tiny point, but we were told the 3 minutes started when we'd finished introducing ourselves, which of itself, by the time you've said, I'm Lorraine Richardson, I do this, I do that, I do the other, well, there's 30 seconds gone. But the 3 minutes started the minute you started speaking. It's a tiny point, but actually
Big
most
difference.
people could have
Yeah.
made another point in that time. But what was interesting, Stu, I found, and this is only an observation, there's probably no comment for you to make as such, but one of the issues and complaints against the Law Society more generally in relation to this whole shooting match was the lack of transparency. And it transpired, and I didn't know because I hadn't made it my business to know who's on the Land Law and Conveyancing Committee, but a number of the people who spoke against the motion, effectively for the Law Society, were people on the Land Law and Conveyancing Committee, but they didn't declare that when they stood up. So, so it rather sort of reinforced that point, I found. But as I say, Stu, I mean, I think the consensus is the Law Society has sort of said, well, you know, yes, we hope to make some changes to the form, but I mean, but what's your experience in practice at the moment? How's it, you know, what are you using? What are other CLC
Well,
firms using? What do you
we're not
see?
really seeing it yet. I still think it's, you know, even the problem with it is you know, now they've sort of kicked the can down the road effectively. You know, we may still be using it in X amount of months time, and of course a lot of the software companies have sort of changed things and whatnot. Law firms that, you know, maybe were going to use it, of course, have changed everything on their system. So whether they go back, I don't know. I mean, we're not personally adopting it, but then we didn't have to, so it's probably a bit different for us. But I do feel for, you know, those firms that, you know, it would have been, you know, deemed compulsory to use, that have now got that sort of onerous task of maybe changing everything, and potentially may have to change it again, you know, come the end of the year or start the year. So it's a difficult one, isn't it? I think the whole way in which, you know, whatever now we want to, you know, we want to talk about sort of, you know, the forms, we want to talk about you know, national trading standards, you know, the information up front, the whole thing's becoming a mess, isn't it? And let's be honest, you know, the terminology that frequently has been used, that, you know, this is an opportunity for conveyancers. If I'm honest, it's turning out to be anything but an opportunity. It's turning out to be an absolute disaster, isn't it? And of course, you know, this is how we come across to maybe our sort of, you know, the estate agent industry, and how we're meant to be working together. Well, it's not a great example at the moment, is it?
No, I mean, I think it's potentially going to drive a massive wedge. I mean,
I think so. Doing the opposite to what it was intended to do.
yeah, I mean, and I genuinely feel for estate agents. I mean, I've, you know, some of them I will criticize till the cows come home. All the sales chasers that don't know what you're telling them when they chase, it is an irrelevant, pointless waste of conveyancers' time, undoubtedly. But there are some excellent agents out there. They don't want to be dealing with, you know, building safety stuff and all of this. And but all of this, one of the concerns I have about all of this is that the Home Buying and Selling Council, the Law Society, is sort of jumping on this bandwagon without seemingly much thought. It's all predicated on the basis, Stu, that sellers and buyers will be instructing their conveyancers upfront at the point a property is either marketed or at the point a property is, you know, a buyer's about to put an offer in. And as you and I discussed last time, Stu, that's just not going to happen.
No.
It's just not going to happen.
No, it's not going to happen. And, you know, we've spoken about sort of, you know, estate agents' appetite to adopt material information. And the last time we spoke about it, you know, was probably 3 months plus ago. Well, nothing's really changed again.
No.
Despite everything that's gone on, nothing's really changed. And, you know, the opportunity word that's bound about, I think, is going to be dissolving very fast.
Yeah, I mean, I suppose to try and be fair, I mean, the counter argument is, well, we are where we are. We're in the situation we're in, so we've got to try and make the best of it. I think that's where the sort of opportunity argument would come from. But unless and until the conveyancer can get in early
But
and advise.
the problem you've got is that, you know, yes, there's an opportunity if there was an appetite to actually roll out material information. And, you know, all industries have spoken about material information for ages now. And in principle, there are elements of it which are a good idea. However, thus far, what has been put into the arena, and if we include clients, state agents, and lawyers, I don't think any out of the three want what's happened.
No,
That's the ultimate position. So you're trying to do something to change, you know, the process of buying property and selling property to make it easier for everybody. But you've introduced something that ultimately I don't think clients particularly want to know about at that stage. Estate agents certainly don't want to get involved, and lawyers are going to struggle to get involved. So I really sort of losing the plot with, you know, the big opportunity that's here at the moment, if I'm
yeah,
honest.
I mean, that's a really brilliant way of putting it, Stu. And I have to say that point hadn't occurred to me at all, that nobody wants what's happened. I mean,
I
that's
don't think they
that's
do.
quite an extraordinary outcome if you think about it, isn't
Yeah,
it?
when you think about it, yeah. I mean, look, I'm not saying that I'm one here that's dead against upfront information. It's the way in which we introduce it, and of course, looking at the benefit for all the individual stakeholders that are going to be, you know, in that pie. And I'm just not sure at the moment where we're going with it, because it just seems that we're not a united front. You've got different fingers in different parts of the pie, not consulting each other.
Yeah, well, this is the interesting thing, because I raised the point at the SGM, the Special General Meeting. I wasn't aware that the Law Society had had a particular consultation or engagement with the Council for Licensed Conveyancers about such a significant change to the conveyancing process. Now, somebody at the meeting did say, "Oh, I think," words to the effect of, I'm not quoting directly because I didn't record it, but retorted to the point I made and said, you know, that they believe the CLC were, you know, contacted, I think was the word. Well, I've certainly had no evidence that there's been any sort of close consultation between the Law Society and the CLC on this, because at the end of the day, as we spoke about last time, Stu, you know, we do run the risk, the Law Society runs the risk of creating a two-tier market, you know, CQS firms that have to use a very defective form and CLC firms that won't. But the CLC, Stu, you know, they're your regulator, you might want to comment. I mean, they did come out a matter of days ago, end of July, they'd had a round table on this. I mean, you know, have you got any sort of views or comments on that?
Not, if I'm honest, not a lot really, because it's just rolling out the same sort of terminology, the same quotes that we've all heard before. So I'm not sure that, you know, the value in the comments and the roundtable that was had.
I think what concerns me a little bit, I have to be honest and say, about the CLC as well, is they do not appear to be taking a position on it for the sake of their regulated community. They are not coming out and saying, okay, regulated lawyers, you know, we think this about, this is our position on the property information form.
It does appear
They're for
very.
it or against it. I'm not suggesting that they should, you know, they should be against it because lots of people like me are, but I think they should be taking a position and giving their regulated lawyers some a steer.
Yeah, I mean, they're obviously leaving it to the industry to make their own choices and so on and so forth, isn't it? But there's a lot of people at the moment that very much sit on the fence. And yeah, you could accuse the CLC of that, but again, I don't know. You know, I think you've got to let the market decide. You've got to let lawyers decide what they want to do.
Well, that, yeah, but CQS firms can't do that if the law
No,
system.
the CLC ones I'm talking
Yeah,
about.
you know, if this, if but CQS firms don't have that luxury. But I mean, for me, the things that I think are questions that remain unanswered, which concern.
Well, I think that's right, Lorraine. I think what you're saying there, that to me would encompass what we're now talking about. We haven't really resolved the problem. We've just kicked it down the road.
Yes.
And that's what obviously we've got to try and endeavour to do, I suppose, over the coming months, because there is a problem with that form. Let's be blunt. I don't think anybody's saying otherwise. And it's, it's trying to resolve that over the next few months. What the Law Society's appetite will be in terms of making, big changes, I'm not sure.
Well, I think that's the problem. I mean, there are certain other factors now. And one of the reasons I wanted us to have this chat is to actually keep the issue in lawyers' minds, because the Law Society has now dragged in a survey firm, and they are going to be conducting a therefore independent survey of conveyancers. Now, anybody can any conveyancer can register with the survey firm via the Law Society's website to contribute to that consultation. And I genuinely urge conveyancers, whether for the form or against it, and I absolutely think that CLC firms should be engaging as well, because actually firms and engaged, conveyancers have till the 16th of August to actually register to be involved in the consultation. So I do genuinely think that all firms have got an interest in this and should be engaging with that consultation. So that's the first thing. What really concerns me, though, is that from sort of March, the Law Society said, oh, well, we're consulting with the profession. Then they found that they had to have an SGM because enough conveyancers said, no, we've had enough. We're going to force you to have a meeting about this because you've handled it so badly. So then they said, oh, well, no, we're going to have a consultation with a independent firm. So one has to say, well, what have they been doing since March? What's that consultation, outcome? And then in the midst of all that, and just sort of around the time they were having the SGM, they advertised, and I believe it was advertised before, I haven't checked, and this has been pointed out to me, which is fair enough. But they certainly made a lot more of the fact that they were offering in consultation, again with a separate organisation, training for estate agents on material information, which included talking about the PIFs. So, but even if that training had been set up before the SGM, and I'm willing to accept it may well have been, if somebody said it was, it was. But the point is they haven't really advertised it much until after. So but one still has to say, well, if they were serious about this consultation, why are they doing training, I think it was last week, for estate agents on material information when they're in the middle of a consultation about the forms?
Makes no sense, does it?
It absolutely doesn't. Now, I suspect it was probably quite expensive and not many people attended. If anybody from the Law Society wants to come on and put me right, genuinely be delighted to see you. But apart from all of those things, so it's the optics of it, Stu, that still concern me. The optics about a lack of transparency, the timing, what was the previous consultation for, and how much is this costing us? How much is this costing the likes of me?
Yeah.
And firms? That's what I'm interested to know, because it's going to be an extraordinary amount of money once we've gone through this whole process. But from a technical point of view, the things that still continue, the questions that remain unanswered for me, Stu, are why does the Law Society not think that the principle of caveat emptor is substantially damaged by the PIF when they're specifically asking buyers to talk about sellers rather, to talk about construction materials and building safety? So that's the first thing. Why do they think that this isn't just driving a tank onto the buyer's lawn by asking about coastal erosion, flooding, whatever, and flood risk? And can the Law Society give any reassurance to conveyancers that that sellers aren't going to be at a massive increased risk of misrepresentation as a result of filling in these forms, without advice? Because that's what's actually going to be happening on the ground. And I cannot see how the Law Society can reassure conveyancers about that. But I very much like them to, if they want to come on, to actually have a discussion rather than just a swapping of, individual thoughts. I would be genuinely delighted to have the discussion with anybody that wants to come on. Not from a, I want to score points and be negative about it point of view, but actually to try to help the profession understand what's going on. Because the Law Society, Stu, actually were at pains to say, oh, well, we took legal advice and there's no additional criminal liability on conveyance as a result of the form. But they didn't, to my mind, really address at all at the misrepresentation point, which I think, for you and your client base is a big thing, isn't it?
Absolutely. Yeah. It's again, it goes back to so many things that were introduced into our industry over the years. It's the practical implementation and how things work practically rather than a paper exercise. And, it's undoubtedly a lot more risk now because of that. Undoubtedly.
Yeah, and I mean the reality is whether they like it or not. I mean, I noticed that, and I absolutely do not and have no intention of mentioning any names. I don't know who they are, but the Law Society's Conveyancing and Land Law Committee, no doubt, got some very, very bright, experienced people on there. But the Law Society did make a point once and said something like, well, they've got a huge amount of experience of amending these forms. But what I couldn't see that many, if any of them had, is direct conveyancing coalface experience today. And that's what's been missing from the dialogue. And
Absolutely.
of course, anecdotally, what I'm reading on social media, as I'm sure you are, is lots of these forms are out there and the sellers aren't answering them properly. So
That's only good. That's only going to be what happens.
yeah,
Yeah.
it's going to create more time. So
Yeah.
I think there's, fair play. I mean, the Law Society had to hold the SGM, so it's not a case of saying, "Oh, weren't they lovely for holding it?" But I still think there's a lot that remains unanswered. I don't want to sound just negative for the sake of it. This is born out of genuine concern for the profession and
Yeah.
our clients. And I think to sort of say, well, we are where we are, so we've got to make the best of it. That may be where we end up, Stu. But I have to say, I do think that's perhaps a little bit naive. But I'm with you. I struggle with this presents an opportunity thing.
Yeah.
Without any
Absolutely.
doubt. So,
Yeah.
a person at the top of a significant conveyancing firm, have you got any closing thoughts on this, Stu, for now?
Not really, other than I've already discussed. It's one of those, isn't it? It's gonna rumble on now. And it's something that's not going to go away. But for me, it's just, what are we actually trying to do? I'm starting to lose sight of, what the end goal with it is. It surely should be about speeding up the conveyancing process and helping clients. But the way it's going, it's going to do anything but that. Certainly not going to help the conveyancing profession. That's absolutely for certain.
Yeah, absolutely. Well, Stu, again, I would just conclude by urging conveyancers that haven't yet registered an interest to go to the Law Society's website before the 16th of August to register an interest to be involved in the consultation, because I think that's really important for people who are for the form as well as against it, and CLC firms just as much as CQS.
Definitely.
I do think that's really important. And I suspect, Stu, that this might be something we talk about again.
I reckon it might well be.
All righty, Stu. Well, you take care.
Take care, Lorraine. See ya.
Bye.